Before we begin, a quick and important disclaimer. The information presented in this video regarding divorce, family law, child custody, alimony, and financial settlements is intended strictly for educational and entertainment purposes only. It does not constitute professional, legal, or financial advice. Family law is incredibly complex and varies drastically from state to state and jurisdiction to jurisdiction within the United States. Every individual marriage and separation involves highly specific variables. We strongly urge all viewers to conduct their own due diligence and consult with licensed family law attorneys, certified financial planners, and tax professionals before making any legal or financial decisions regarding their personal circumstances. Imagine walking into a wood-paneled American courtroom in the year 1924, and then immediately fast-forwarding to a sterile, brightly lit family court mediation room in the year 2024. In the span of exactly 1 century, the fundamental legal definition of marriage, the dissolution of that union, and the subsequent financial and custodial fallout have undergone a radical, unrecognizable transformation. If you are a man living in the United States today, the legal system you enter when you commit to a marriage contract is built upon 100 years of legislative trial and error, shifting cultural paradigms, and profound legal precedents that the vast majority of citizens never study until it is too late. The shock of this realization is often the first, most devastating blow of a modern divorce. Consider the statistical reality of the present day. While modern culture frequently champions the idea of absolute parity and equal division, the actual data pulled from courtrooms across the nation paints a much more complex and geographically fragmented picture. According to recent demographic analyses and studies on national child custody statistics by gender, a father's access to his children post-divorce is heavily dictated by the mere geographical coordinates of his home. In states like Connecticut, Maine, and New Mexico, the trend has moved toward a 50-50 division of parenting time, granting each parent roughly 182 days with their children. However, this is far from the universal standard. If you look at a state like Texas, fathers are awarded approximately 33% of parenting time, amounting to roughly 120 days a year. The disparity deepens in states like Utah, where men historically receive about 26% of custody time, and plummets in Tennessee, where national studies have shown fathers receiving as little as 21% of parenting time, leaving them with roughly 80 days a year with their own children. +1. These numbers represent the stark, undeniable reality of a legal apparatus that has evolved in disjointed, erratic phases. How did we arrive at a system where a father's legal right to see his child is so drastically influenced by state lines? How did we transition from the 19th century, a time when fathers were legally recognized as having absolute custody and control over their children as the head of the household, to the 20th century adoption of the tender years doctrine, which overwhelmingly presumed that mothers were the uniquely essential caregivers for young children? And furthermore, how did that doctrine slowly morph into the modern best interests of the child standard? A standard that, while theoretically gender-neutral on paper, often leaves men fighting uphill battles in courtrooms where historical biases still silently influence judges' gavels. More importantly, how are modern men meant to navigate the devastating financial terrain that accompanies these custodial battles? The economic mechanics of divorce for men have shifted just as dramatically as the custodial ones. We are talking about a system that initiated child support enforcement heavily in the latter half of the 20th century, originally designed as a welfare cost recovery mechanism. When the federal government partnered with states to recoup the costs of the Aid to Families with Dependent Children program, it created an aggressive enforcement apparatus. Today, that apparatus has the power to garnish up to 2/3 of a non-custodial parent's wages, intercept tax refunds, suspend driver's licenses, revoke professional and occupational licenses, and even initiate incarceration for arrears. Studies have shown that a significant majority of those carrying severe child support debt are individuals with incredibly low annual incomes, highlighting a systemic cycle where financial struggle is met with severe punitive action rather than structural assistance. +2. This brings us to the core problem that this masterclass solves for you today. If you are an American man who is currently married, considering taking the leap into matrimony, or already standing in the daunting shadow of the family court system, the sheer volume of legal mechanisms working behind the scenes can feel entirely overwhelming. The primary cause of devastation in modern divorce is not simply the emotional severing of a relationship. It is the absolute lack of preparation and historical awareness regarding the business and legal contract of marriage. Men consistently enter these proceedings blind to the historical trends that have shaped the laws governing their assets, their future income, and their parental rights. This deep dive is designed to cure that blindness. Over the course of this comprehensive series, we are going to meticulously decode the century of change that has built the modern American family court system. By examining historical trends, analyzing specific legislative shifts, and reviewing detailed case studies, you will gain the clarity necessary to understand the exact landscape you are navigating. We will break down the precise evolution of alimony, from a system designed to prevent destitute women from becoming wards of the state, to the modern applications of rehabilitative, permanent, and reimbursement alimony. We will explore the seismic impact of the no-fault divorce revolution, which began in California in 1969 and systematically swept across the nation, permanently altering the leverage dynamics of marital dissolution by allowing a contract to be dissolved unilaterally without proving wrongdoing. We are moving far beyond the surface-level advice you hear in casual conversation. We are looking at the raw data, the statutory structures, and the potential outcomes of engaging with a system that has been continuously patched, revised, and overhauled for 100 years. You will learn how the concept of marital property transitioned into the modern frameworks of equitable distribution versus community property, and how those specific legal frameworks dictate whether your business, your retirement accounts, and your real estate will be split down the middle or divided based on a judge's subjective view of fairness. This knowledge is not about fostering bitterness or resentment. It is about equipping you with pragmatic, objective reality. When you understand the origin of the rules, you can adequately prepare for the game. You can set realistic expectations for legal proceedings, you can ask your legal counsel the right questions, and you can structure your financial life with a protective, forward-thinking strategy. Understanding the history of child custody, the origins of child support calculations, and the shifting attitudes toward alimony is the only way to strategically navigate potential outcomes and mitigate catastrophic losses. We are going to examine the shifting demographics, including the rising rates of gray divorce among couples over the age of 50, and the specific vulnerabilities men face when attempting to reconstruct their financial stability late in life. By the time we conclude this foundational exploration, you will possess a comprehensive, historically grounded understanding of the American family court apparatus, transforming you from a passive participant into an informed, strategic advocate for your own future and your relationship with your children. Let us begin by uncovering the exact moment the legal balance of power first began to shift, and how the echoes of early 20th century lawmakers are still directly impacting your wallet and your family today. To understand the magnitude of this shift, we have to rewind to a legal framework that would seem entirely alien to any man walking into a family court in 2026. Under early English common law, which formed the absolute bedrock of American jurisprudence, a legal concept known as paternal preference ruled the day. In this era, children were legally viewed as the property of their father, much like real estate or livestock. If a marriage dissolved, which was an incredibly rare and socially taboo event, the father almost automatically retained custody of the children and total control of the marital assets. The mother, legally speaking, was absorbed into the husband's legal identity under a doctrine called coverture. Because the man carried the sole legal liability for his family's debts and actions, the state granted him absolute authority over the family unit. But as the United States transitioned from a purely agrarian society into an industrial powerhouse during the 19th and early 20th centuries, a massive socio-economic earthquake occurred. Men were systematically pulled away from the family farm to work long, grueling hours in factories and urban centers. Women, by necessity, increasingly became the primary, and often the sole, domestic caregivers. The legal system, always a lagging indicator of cultural change, slowly adapted to this massive shift in daily life and birthed the tender years doctrine. This doctrine created a rigid legal presumption that during a child's early developmental years, typically defined as under the age of 7, the mother was the uniquely necessary and proper parent to hold sole custody. Imagine a man named Thomas living in the year 1926. If Thomas and his wife decided to divorce, the courtroom was a literal theater of fault. Thomas could not simply tell a judge that they had irreconcilable differences or that they had grown apart. To dissolve the binding legal contract of marriage, one party had to present absolute proof that the other committed a severe matrimonial offense. The accepted grounds were incredibly strict, usually limited to proven adultery, extreme physical cruelty, or prolonged abandonment. This required hiring expensive private investigators, staging elaborate and often humiliating photographs, and publicly destroying each other's reputations on the permanent public record. If Thomas was found at fault by a judge, he could be stripped of everything he owned. But if he proved his wife was at fault, the tender years doctrine might be bypassed entirely, and he could retain his wealth, his reputation, and his family. The entire legal system was predicated on the absolute necessity of finding a villain and a victim. Now, fast forward exactly 1 century to the year 2026. Imagine a man named David, a 35-year-old mid-level executive living in Ohio. David is facing the exact same dissolution of a marriage contract, but the battlefield has been completely and irrevocably terraformed. The absolute necessity of proving fault has vanished, replaced by the sweeping nationwide adoption of no-fault divorce laws. Furthermore, the tender years doctrine was officially struck down by appellate courts in the latter half of the 20th century for violating the Equal Protection Clause of the 14th Amendment. On paper, the system David faces today is entirely gender-neutral. The courts now mandate that decisions must be made under the best interests of the child standard. But here is where historical trends and modern reality collide with devastating force for men like David. While the written law is meticulously crafted to be blind to gender, the daily execution of that law is carried out by human judges who carry the inherited cultural biases of the past century. The best interests of the child standard sounds beautifully egalitarian to the general public, but in legal practice it is deeply and dangerously subjective. It requires a judge to weigh specific, highly granular factors. They look at which parent has historically been the primary caregiver. They look at who schedules the pediatric appointments, who attends the midday parent-teacher conferences, and who purchases the children's clothing. In 2026, millions of households still operate with a practical division of labor where the father earns the primary income to support the family infrastructure, necessitating 40 to 60 hours a week away from the physical home. When David walks into court, his absolute dedication to providing financial stability is often silently weaponized against him under the best interest standard. The mother, having spent more absolute hours physically present with the children due to David's demanding work schedule, is easily positioned by opposing counsel as the primary caregiver. The ghost of the tender years doctrine is immediately resurrected, not as a formal written law, but as a subtle, pervasive judicial preference. David discovers to his horror that his traditional role as a provider has inadvertently sabotaged his legal claim to equal 50-50 parenting time. This subjective standard does not just dictate whether David sees his children on alternating weekends and Wednesday evenings. It fundamentally alters the trajectory of his financial future. Because custody calculations and child support formulas are inextricably linked by state software programs, David's reduced parenting time mathematically guarantees a massive monthly child support obligation. But the financial untangling goes even deeper when we examine the evolution of alimony, historically known as spousal support. In the bygone era of fault-based divorce, alimony was essentially a punitive measure against a cheating husband or a protective, state-mandated stipend for a wronged woman who had absolutely no legal means of entering the workforce. But as no-fault divorce swept the nation, the legal justification for alimony had to evolve rapidly. Let us look at a scenario based on recurring historical trends in the modern era. A man marries in the year 2006. His wife mutually agrees to pause her career to raise their children. 20 years later, in 2026, she files for a no-fault divorce due to simply feeling unfulfilled. Under modern statutes, she can seek rehabilitative alimony, which forces the husband to pay for her education and living expenses while she retrains to re-enter the workforce. In many jurisdictions handling long-term marriages, she can seek permanent alimony, demanding the husband maintain the exact standard of living established during the marriage indefinitely. The modern court looks at the husband's 20 years of continuous career advancement and essentially treats his earning capacity as a joint marital asset. He is now legally obligated to subsidize 2 completely separate households on a single income, a mathematical impossibility that forces thousands of men into chronic debt, liquidating retirement accounts, or eventually filing for bankruptcy. The historical shift from fault to no fault meant that a man could be perfectly faithful, an excellent father, and an exemplary financial provider, yet still lose 50% of his accumulated wealth, his daily access to his children, and a significant portion of his future earnings simply because his spouse unilaterally decided to terminate the contract. We have seen how the removal of fault and the highly subjective interpretation of the best interest standard created a perilous, unpredictable landscape for men. But the most dangerous financial landmine in family court is not necessarily the child support calculations or even the threat of permanent alimony. The true, lasting devastation often occurs during the highly technical, deeply contentious process of asset division. What happens when a judge is legally empowered to divide not just the cash sitting in your joint checking account, but the future projected value of a business you built from the ground up, the entirety of your military pension, or even the subtle market appreciation of a house you purchased years before you even met your spouse? The modern rules of marital property are far more aggressive and invasive than you think, and in the next part of this masterclass, we are going to meticulously dissect the precise mechanisms the court uses to legally liquidate your life's work, starting with a specific legal classification that has bankrupted countless men before the ink on their divorce decree is even dry. That legal classification is the seemingly innocent but highly lethal concept of marital property versus separate property, and more specifically, the catastrophic legal doctrine known as transmutation. To grasp how entirely the landscape has shifted, we must look at the historical trends of property ownership. A century ago, the legal system operated almost exclusively on a title-based system. If a man purchased a parcel of land or a business and his name alone was inscribed upon the deed or the incorporation documents, that asset was his separate property, insulated from the financial fallout of a marital dissolution. The court simply looked at the physical paperwork to determine ownership. But as the 20th century progressed and the legal system sought to provide more robust financial protections for spouses who did not directly earn wages, the sheer power of the title was systematically dismantled. Today, in the year 2026, the name on the deed, the title of the vehicle, or the sole proprietorship documentation is often rendered entirely irrelevant the moment a divorce petition is filed. The modern American legal system divides the nation into two distinct property distribution frameworks: community property and equitable distribution. Understanding which framework governs your jurisdiction is the most critical foundational knowledge any man can possess. In the 9 community property states, which include massive population centers like California and Texas, the law dictates a rigid, statutory 50-50 split of all assets and all debts acquired from the exact date of marriage to the exact date of separation. However, the vast majority of the country, 41 states, operates under equitable distribution. The word equitable is perhaps the most misunderstood and dangerous term in modern family law. Men frequently enter courtrooms assuming equitable means equal, expecting a straightforward division of assets. Instead, equitable translates to what a single presiding judge subjectively determines to be fair based on a complex matrix of statutory factors, including the length of the marriage, the earning capacity of each spouse, and the physical health of both parties. But the true peril for men lies in how separate premarital assets are dragged into this distribution pool, through the doctrine of transmutation and the process of commingling. Let us examine a highly common case study reflecting potential outcomes in 2026. Imagine a man named Robert, a 42-year-old software engineer living in an equitable distribution state like New York. 5 years before he even met his future wife, Robert purchased a home for $300,000. He made the down payment from his own savings, and only his name is on the mortgage and the deed. By all historical logic, this home is his separate property. He gets married in 2021, and the couple lives in this home until filing for divorce in 2026. Robert assumes his premarital home is safe. He is entirely incorrect. The moment Robert got married, the wages he earned at his engineering job legally transformed into marital funds. Because Robert continued to pay his mortgage using his salary during the 5 years of marriage, he was actively using marital property to pay down the principal on a separate asset. Furthermore, if his wife used a few $100s to paint the living room, or if they jointly paid for a new hot water heater, she contributed to the active appreciation of that property. Through the legal magic of transmutation, a significant percentage, if not the entirety, of the home's increased equity over those 5 years has been legally transformed into marital property subject to division. The court will not simply give Robert his house, they will order a forensic appraisal, calculate the marital contribution, and force Robert to either buy out his wife's newly manufactured equity using liquid cash, or mandate the immediate sale of his premarital home to satisfy the debt. This exact mechanism of financial extraction becomes exponentially more devastating when applied to male entrepreneurs and business owners. Imagine if Robert did not just own a home, but had spent the 10 years prior to his marriage building a successful regional logistics company. Again, he assumes the business is insulated because it was established long before the marriage certificate was signed. However, modern family courts view the active effort, the intellectual labor, and the daily management a man pours into his business during the marriage as marital contributions. The court will appoint a forensic accountant to dissect 10 years of corporate tax returns, profit and loss statements, and balance sheets. This is where the concept of business goodwill is introduced into the courtroom, a highly subjective valuation metric that has destroyed countless men financially. The forensic accountant will separate personal goodwill, which is the value derived specifically from Robert's unique relationships and reputation, from enterprise goodwill, which is the value of the business entity itself. In many states, enterprise goodwill is considered a divisible marital asset. The accountant will look at the growth of the business from the date of marriage in 2021 to the date of separation in 2026. If the business grew in valuation by $2 million during that 5-year window, the court can dictate that $1 million belongs to the spouse. Herein lies the ultimate liquidity crisis for the modern divorced man. The court has just awarded $1 million of business equity to a spouse who never worked a single day in the logistics company. But a business valuation is not liquid cash in a checking account. It is tied up in trucks, warehouses, and accounts receivable. To satisfy the court's equitable distribution order, Robert is faced with a catastrophic dilemma. He must either take out massive, high-interest commercial loans to pay off his ex-wife, effectively crippling the operating cash flow of his company, or he is forced to liquidate the very business that sustains his livelihood and provides his ability to pay the inevitable child support and alimony burdens we discussed previously. The historical trends clearly show that the legal definitions of property have expanded aggressively over the last century, constantly seeking new pools of capital to divide in the name of equity. Men are losing half of their historical labor because they fundamentally fail to understand how the mere act of signing a marriage contract instantly overrides the names printed on their property deeds and business ledgers. They fail to establish prenuptial or postnuptial firewalls because they do not comprehend the aggressively invasive nature of the modern discovery process. But the liquidation of homes and businesses is only the opening salvo in the battle for your accumulated wealth. There is an even larger pool of capital that men spend their entire adult lives building, completely unaware that a specific, highly technical federal law allows a state judge to bypass decades of financial protection and slice directly into their future survival. What happens when the court looks past your current checking account and sets its sights on the money you are legally required to hide away for your old age, utilizing a terrifying piece of paperwork that can legally raid your 401k before you ever reach retirement? That terrifying piece of paperwork is known as the Qualified Domestic Relations Order, commonly referred to as a QDRO. To fully comprehend the sheer, unmitigated power of this legal instrument, we must first examine the historical trends of retirement protection in the United States. In the mid-20th century, as corporate pensions and early retirement accounts became standard, the federal government passed the Employee Retirement Income Security Act of 1974, widely known as ERISA. The original intent of ERISA was to create an absolute, impenetrable fortress around a worker's retirement savings, shielding those funds from creditors, bankruptcies, and civil judgments. A man's pension was considered his untouchable life raft for his twilight years. However, a massive legislative shift occurred exactly 1 decade later with the passage of the Retirement Equity Act of 1984. This act carved out a singular, catastrophic exception to the ERISA protections, formally decreeing that state-level family courts could legally pierce the federal fortress of retirement accounts to satisfy child support, alimony, and marital property divisions. The QDRO was born, serving as the specialized legal key designed to unlock and drain those protected funds. The QDRO is not merely a suggestion to your financial institution. It is a binding federal court mandate that completely bypasses your personal control as the account holder. Once signed by a judge, it is sent directly to your plan administrator, whether that is Fidelity, Vanguard, or your corporate human resources department. The plan administrator is legally obligated to slice your account and create a separate account for your ex-spouse, or issue a direct cash distribution to them. Let us examine the exact mathematical devastation this inflicts using a case study. Imagine a man named Michael in the current year, 2026. Michael is a 50-year-old regional sales director living in Illinois. Over the course of his 25-year career, he has diligently sacrificed and invested, building a 401k balance of $800,000. He has been married for 15 of those 25 years. When Michael enters the divorce process, he often assumes the court will only look at the money saved during the exact years of the marriage. He is only partially correct, and the formula used to extract the funds is incredibly complex. Courts utilize a mathematical formula, known as the coverture fraction, to determine the marital portion of a retirement account. Step by step, the coverture fraction works like this. The court takes the total time Michael was married while participating in the retirement plan, which is 15 years. They then divide that number by the total time Michael has been participating in the plan overall, which is 25 years. 15 divided by 25 equals 60%. The court has just legally determined that 60% of Michael's entire $800,401,000, which equates to $480,000, is classified as divisible marital property. Because Illinois is an equitable distribution state, the judge then awards half of that marital portion to Michael's ex-wife. Through the execution of the QDRO, $240,000 is permanently extracted from Michael's account. But the tragedy of the QDRO is not merely the loss of the principal balance. The true, hidden devastation is the absolute destruction of Michael's compounding interest curve right as he enters his peak growth years. Financial mathematics dictate that the bulk of investment growth happens in the final decade before retirement, as the principal base is large enough to generate massive compound returns. By legally extracting $250,000 at age 50, the court does not just take current money. It annihilates the hundreds of thousands of dollars in future interest that money would have generated over the next 15 years. Michael is forced to restart his compounding engine with a severely diminished base, radically altering his entire life expectancy and forcing him to potentially work deep into his 70s. This extraction process becomes even more treacherous when men attempt to negotiate their way out of it through asset trading. A massive, recurring pitfall for men in 2026 is the house for pension trade. Desperate to keep their retirement accounts intact, men will frequently offer to let their ex-wife keep the entire marital home in exchange for keeping the entire 401k. On paper, this looks like a fair trade. If the home has $300,000 in equity, and the ex-wife's share of the 401k is $300,000, men assume it is a clean swap. This is a catastrophic financial illusion based on a failure to understand tax law. A house is a heavily illiquid asset that requires constant capital input through property taxes, maintenance, and insurance. Furthermore, the equity in a primary residence is often shielded from capital gains taxes upon sale under current tax codes. A traditional 401k, however, is comprised of pre-tax dollars. When Michael finally retires and begins withdrawing that $300,000, every single dollar will be taxed at his ordinary income rate. By trading a tax-advantaged, appreciating physical asset for a heavily taxed, future distributed asset dollar for dollar, Michael is effectively taking a massive financial loss that he will not fully realize until he is too old to recover. This systemic division extends far beyond corporate 401k plans and aggressively targets military and civil servants. If you are a veteran, the historical trend regarding your pension is equally stark. Prior to 1981, the Supreme Court ruled that military pensions were not divisible as community property. However, Congress quickly retaliated by passing the Uniformed Services Former Spouses Protection Act in 1982. This act formally allowed state courts to treat military retirement pay as marital property. It established the notorious 10-10 rule, dictating that if a marriage lasted at least 10 years, and those 10 years overlapped with 10 years of creditable military service, the Defense Finance and Accounting Service is authorized to send the ex-spouse's share of the pension directly to them every single month. Men who have sacrificed their physical and mental well-being in active combat zones find that the financial compensation for their literal blood and sacrifice is subject to the exact same equitable distribution software used for a civilian's mutual fund. The psychological toll of this widespread financial liquidation is driving one of the most alarming demographic trends in 2026, known as the gray divorce phenomenon. The rates of divorce for men over the age of 50 have skyrocketed. When a man is subjected to property liquidation, business valuation splits, and the QDRO extraction of his retirement late in life, the potential outcomes are structurally dire. He no longer possesses the biological time horizon to rebuild his capital through labor. He is stripped of his past earnings, his present assets, and his future security in a matter of months. We have now extensively covered the systematic liquidation of the past and the present through home sales, business appraisals, and the surgical extraction of your retirement future through the QDRO. We have seen how the courts divide what you have already built. But what happens when the legal system decides that dividing your existing assets is simply not enough? What happens when a temporary marital contract results in a permanent, inescapable tax on your future labor, transforming you into an involuntary financial guarantor for another adult for the rest of your natural life? The legal concept we are directly confronting is alimony, historically known as spousal maintenance or spousal support. To comprehend the absolute peril this poses to modern men, we must fundamentally deconstruct the historical trends that birthed this system. A century ago, alimony was a strict, localized necessity. Under the legal doctrine of coverture, a woman was practically absorbed into her husband's legal and financial identity. She was heavily restricted from opening bank accounts, securing lines of credit, or entering most professional fields. If a marriage dissolved, the state mandated alimony to prevent the former wife from becoming utterly destitute and entirely reliant on public welfare. The state was protecting its own treasury by forcing the former husband to bear the lifelong financial burden. However, we are now operating in the year 2026. The societal landscape has undergone a tectonic shift. Women comprise roughly half of the modern workforce, outpace men in university graduation rates, and hold significant economic independence. Yet, the statutory framework governing alimony in numerous jurisdictions remains stubbornly anchored to the 19th century. Instead of acting as a temporary safety net to prevent extreme poverty, alimony has morphed into a complex wealth transfer apparatus designed to artificially sustain a specific lifestyle. The most dangerous phrase a man will ever encounter in a family law statute is the mandate to maintain the standard of living established during the marriage. Consider the potential outcomes of this mandate. If you are a man who worked 80 hours a week, sacrificed your physical health, and took massive entrepreneurial risks to provide a luxurious lifestyle for your family, the court weaponizes your own success against you. The judge does not look at what your ex-spouse needs to survive. The judge looks at what your ex-spouse has grown accustomed to consuming. If your income provided for luxury vehicles, annual international vacations, and a sprawling residence, the court will frequently attempt to ensure your ex-spouse can continue consuming those exact luxuries without your physical presence, funded entirely by your future labor. Let us examine a highly realistic case study to illustrate the crushing mechanics of this system. Imagine a man named James, a 48-year-old orthopedic surgeon residing in Florida in the year 2026. James has been married for 18 years. His wife voluntarily left the workforce 15 years ago to raise their children, who are now teenagers. Because the marriage falls into the category of a long-term marriage, typically defined as anything over 10 to 15 years depending on the state, James is immediately exposed to the threat of permanent alimony. The court calculates James's robust income and orders him to pay $10,000 a month in permanent spousal support. But the true danger is not just the initial calculation. It is a terrifying legal doctrine known as imputed income. Imagine if James, after decades of high-stress surgical work, experiences severe physical burnout or develops a slight tremor in his hand, forcing him to step away from the operating table. He transitions into a medical consulting role or a teaching position, and his income drops from $500,000 a year to $150,000 a year. James assumes he can simply go back to family court and ask the judge to legally lower his $10,000 a month alimony payment because he no longer possesses the actual cash flow to afford it. He is profoundly mistaken. When James files his modification petition, his ex-wife's legal counsel will ruthlessly argue that James is voluntarily underemployed. They will argue he intentionally took a lower-paying job to starve his ex-wife of her awarded standard of living. In family court, the judge has the absolute authority to look at James, recognize that his physical paycheck has shrunk, but legally declare that he still possesses the earning capacity of a $500,000 surgeon. The judge will impute his prior income, mathematically pretending that James still makes his previous salary, and refuse to lower the alimony obligation. James is now legally required to pay $10,000 a month out of a vastly diminished pool of actual capital. This mechanism systematically forces men into extreme debt, liquidating any remaining separate assets just to stay out of contempt of court, essentially transforming them into indentured servants to their past earning potential. Furthermore, the mathematical reality of paying alimony in 2026 is structurally vastly more destructive than it was just a decade ago, due to severe shifts in federal tax law. For decades, alimony payments were tax-deductible for the payer and taxable income for the recipient. This provided a slight buffer for the man writing the check. However, the Tax Cuts and Jobs Act, which went into effect for divorces finalized after December 31, 2018, completely eliminated the alimony tax deduction for the payer at the federal level. Let us apply this directly to James. Under the old tax laws, if James paid $120,000 a year in alimony, He could deduct that from his gross income, significantly lowering his tax bracket and his overall tax burden. In 2026, James must pay that entire $120,000 using completely post-tax dollars. He has to earn roughly $200,000 in gross income, pay massive federal and state taxes on it, and then hand over the remainder to his ex-wife. She, meanwhile, receives the money entirely tax-free at the federal level. The modern system forces the man to absorb the entirety of the tax liability, while simultaneously draining his liquid capital. Men often attempt to navigate this inescapable tax on their future labor by relying on the cohabitation clause. In most jurisdictions, permanent alimony can be legally terminated if the ex-spouse remarries or enters into a supportive cohabitation relationship with a new partner. However, historical trends in the family court system show that ex-spouses are acutely aware of this financial cliff. They will engage in elaborate, highly calculated evasive maneuvers to maintain the alimony stream. An ex-wife might spend 6 nights a week at a new partner's home, but intentionally keep an empty apartment in her own name, ensuring her mail is delivered there to legally prove she has not officially cohabitated. To break the chain of permanent alimony, the burden of absolute proof falls entirely on the man. James would be forced to hire private investigators, spending thousands of dollars to meticulously track his ex-wife's movements, photograph her vehicle parked at a new residence overnight, and subpoena financial records to prove she is sharing utility bills or groceries with a new partner. The legal system forces the man into a state of perpetual financial surveillance, draining his resources even further just to prove the economic reality of the situation to a judge who is heavily incentivized to maintain the status quo. We have now meticulously documented the systemic extraction of your past assets, your current businesses, your future retirement, and your ongoing physical labor through permanent alimony and imputed income. You understand the financial devastation. But what happens when financial leverage is not enough for an aggressively advised spouse? What happens when opposing legal counsel realizes that the absolute fastest way to secure total victory in family court is not through forensic accounting, but through the immediate unverified weaponization of the criminal justice system? What happens when a single piece of paper, filed in secret without your knowledge, gives armed law enforcement officers the legal authority to forcefully remove you from your home, permanently separate you from your children, and label you a dangerous threat before you are even allowed to speak a single word in your own defense? That legal mechanism is the ex parte temporary restraining order, frequently referred to in the aggressive lexicon of modern family law as the silver bullet tactic. To understand how a fundamental constitutional right to due process can be so easily suspended, we must first look at the historical trends surrounding domestic violence legislation. In the late 20th century, society rightfully and necessarily recognized a horrific systemic failure to protect actual victims of domestic abuse. Legislative bodies across the United States rapidly enacted stringent, highly responsive domestic violence statutes and protective order protocols. These laws were, and remain, fundamentally necessary to save lives in genuinely dangerous situations. However, when we analyze the evolution of family court litigation over the last 40 years, a terrifying parallel reality emerges. Aggressive legal strategists realize that these exact protective statutes, designed as a vital shield for the vulnerable, could be easily inverted and weaponized as a devastating tactical sword in the opening days of a marital dissolution. The Latin term ex parte translates to from one party. In the American legal system, the absolute bedrock of justice is the concept that you have the right to face your accuser and present a defense before you are stripped of your property or your liberties. The ex parte protective order operates as a singular, catastrophic exception to this rule. It allows one spouse, accompanied by their legal counsel, to walk into a judge's chambers without you, your lawyer, or anyone representing your interests being notified or present. The evidentiary standard required to grant this temporary order is incredibly low. Unlike a criminal trial that requires proof beyond a reasonable doubt, an ex parte order frequently requires nothing more than a sworn written affidavit or a brief, unchallenged verbal testimony from one spouse alleging a fear of imminent harm. No police reports of past violence are strictly required. No medical records are mandated. No independent witnesses need to be called. The judge, operating under the immense pressure of acting with an abundance of caution to prevent potential tragedy, will almost uniformly sign the order based purely on unverified allegations. Let us examine the precise potential outcomes of this mechanism, using a highly realistic scenario, based on current trends in the year 2026. Imagine a man named William, a 40-year-old high school principal with an unblemished professional and personal record. He and his wife have been experiencing marital friction, but there has never been a physical altercation. William arrives home on a Friday afternoon, a specific time strategically chosen by opposing counsel because the courts immediately close for the weekend, preventing William from accessing emergency legal intervention. Instead of his family, William is greeted in his driveway by two armed law enforcement officers. They hand him a piece of paper, the temporary restraining order. In that exact, devastating second, William's entire reality is legally disassembled. The order mandates that he has 10 minutes to pack a single bag of essential clothing under the watchful eyes of the police. He is immediately and legally barred from entering his own home. He is ordered to surrender any firearms he legally owns. Most catastrophically, a mandatory no-contact order is instantly placed between William and his children. If William attempts to send a single text message asking if his children are safe, if he drives past their school, or if he attempts to access his own driveway, he will not be cited for a civil family court violation. He will be immediately arrested and incarcerated for committing a criminal offense. Why do aggressive family law attorneys actively suggest this deeply unethical strategy to their clients? Because the strategic leverage gained in those opening hours is nearly insurmountable. By securing an ex parte order, the opposing spouse has instantly bypassed months of agonizing custody mediation. They have artificially established an immediate status quo of having sole, exclusive physical custody of the children. As we discussed previously, the modern family court's best interests of the child standard relies heavily on maintaining stability and the status quo. When the eventual custody trial occurs months later, the mother's attorney will argue that the children are already accustomed to living solely with her, using the manufactured separation to justify permanent primary custody. Furthermore, this tactic initiates an immediate, crushing financial bleed-out for the man. William is legally ousted from the marital residence, granting his wife exclusive use and possession of the property. However, his legal obligation to maintain the marital estate remains entirely intact. William is now forced to pay the monthly mortgage, the property taxes, and the utility bills for a house he faces jail time for approaching. Simultaneously, he must immediately secure first and last month's rent for a long-term executive apartment or hotel, effectively doubling his housing expenses overnight, while facing the most expensive legal battle of his life. The constitutional right to due process does eventually arrive, but it is heavily delayed. A formal evidentiary hearing to determine if the temporary order should be made permanent is usually scheduled 14 to 21 days after the initial Friday ambush. During those 2 to 3 weeks, the psychological damage is profound. William must hire a specialized defense attorney, often requiring emergency retainers ranging from $10,000 to $20,000, completely draining his liquid savings before the actual divorce has even technically begun. When the hearing finally occurs, William's attorney can present evidence, cross-examine the spouse, and expose the false allegations. Frequently, when faced with the actual burden of proof and cross-examination, the requesting spouse will simply voluntarily drop the restraining order right before the hearing begins, claiming they feel safe now that the divorce is underway. But the strategic objective has already been completely achieved. The court system rarely penalizes the spouse for perjury or filing a frivolous order, viewing it as a subjective misunderstanding of fear. William, however, has lost tens of thousands of dollars, has been traumatized by forced separation from his children, and begins the multi-year divorce process entirely on the defensive, completely stripped of his negotiating power. For men in specific professions, the collateral damage is even more severe. A temporary restraining order is entered into state and federal law enforcement databases. For a high school principal like William, a medical doctor, a police officer, an active duty military member, or any professional holding a federal security clearance, the mere automated notification of this filing can trigger an automatic suspension without pay pending an internal investigation, or even immediate termination of employment. The ex parte tactic does not just seek to win the custody battle. It possesses the extreme potential to permanently annihilate a man's career, cutting off his ability to fund his own legal defense. We have now witnessed how the legal system can be manipulated to forcefully eject you from your property, instantly sever your physical access to your children, and subject you to severe financial and professional ruin under the guise of statutory protection. You have been financially sidelined and physically removed from the daily mechanics of your family's life. But the most insidious, long-lasting damage of this manufactured separation is not happening to your bank account or your professional reputation. It is happening silently inside the minds of the children you were forced to leave behind. What happens when this sudden physical absence is actively weaponized to systematically rewrite a child's memories, transforming them into a psychological weapon programmed to fear and despise the very father who spent his entire life providing for them? That psychological reprogramming is known within the clinical and legal communities as parental alienation. To understand the sheer destructive power of this dynamic, we must look at historical trends within family court psychology. For decades, the courts viewed a child's rejection of a parent purely as a natural consequence of the divorce itself, or a reflection of the rejected parent's inherent flaws. However, as psychological analysis deepened in the late 20th and early 21st centuries, experts identified a very specific systemic pattern of psychological manipulation. Parental alienation is not simply a child being upset about a changing living situation. It is the deliberate, calculated campaign by one parent to systematically destroy the relationship between the child and the other parent, utilizing emotional coercion, false narratives, and absolute gatekeeping. When an ex parte order or a hostile separation physically removes a father from the household, it creates an immediate emotional and physical vacuum. The alienating parent quickly fills this vacuum with a highly curated, deeply toxic narrative. Imagine a man named Christopher in the year 2026. Christopher is a civil engineer who, after being legally ousted from his home, is restricted to seeing his 10-year-old daughter for only a few hours every other weekend, often at a sterile, supervised visitation center. He arrives for his visit carrying a birthday present, only to find his daughter refusing to look at him, addressing him by his first name instead of dad, and physically recoiling from his presence. How did this absolute rejection materialize in just a few months? The alienation process is executed through specific, highly observable phases. First comes the subtle undermining and the rewriting of history. The alienating parent will explicitly tell the child that their father voluntarily decided to abandon them, framing a court-ordered legal eviction as a malicious personal choice. Next comes the physical erasure of the father's existence. All photographs of Christopher are removed from the house. Gifts he purchases are immediately thrown away or hidden. When the child speaks positively about a past vacation with him, the alienating parent reacts with visible distress, crying or becoming angry. This implicitly trains the child that expressing any love or affection for their father directly causes severe emotional pain to their primary, custodial caregiver. Then, the manipulation escalates to active, aggressive interference. Christopher is court-ordered to have a phone call with his daughter every Tuesday evening at 7 o'clock. He calls repeatedly, but the phone rings unanswered. The mother later tells the child that Christopher did not even bother to call, while actively hiding the ringing phone in another room. Over time, the child, completely dependent on the primary caregiver for physical survival, food, shelter, and emotional approval, begins to adopt the alienating parent's hostility as their own internal reality. This is a recognized psychological survival mechanism. To reject the father is to perfectly align with the mother, ensuring absolute safety and acceptance in a highly chaotic and frightening environment. When Christopher brings this immediate crisis to the attention of the family court, he encounters one of the most agonizing systemic failures of the modern legal apparatus. The family court operates at a slow, bureaucratic crawl, while psychological damage occurs at lightning speed. By the time Christopher secures a hearing months later to address the missed phone calls and the blocked visitations, the alienation is deeply entrenched. The judge will often bring the 10-year-old into chambers for a private interview. The child, having been heavily coached, will confidently state that she hates Christopher, that he is scary, and that she absolutely does not want to see him ever again. Historically, courts heavily weigh the stated preferences of an older child under the best interest standard. The judge, lacking deep clinical psychological training, frequently takes the child's manufactured hostility at face value. They fail to recognize that the child is simply reciting a script written by the alienating parent. The court essentially validates the emotional abuse, punishing Christopher for the very alienation he is suffering by officially reducing his parenting time, even further to respect the child's wishes. Christopher is caught in a catastrophic double bind. If he fights aggressively in court to see his daughter, the opposing counsel labels him controlling and demanding. If he backs off to give his daughter emotional space, the opposing counsel claims he is disinterested and neglectful. There is no winning move within the standard legal framework. To supposedly combat this, the court will often order Christopher to engage in reunification therapy. This introduces another layer of catastrophic financial extraction. Reunification therapy is almost never covered by standard health insurance because it is an active court mandate rather than a traditional medical necessity. Christopher is forced to pay hundreds of dollars an hour for specialized therapists who attempt to slowly undo the psychological damage during weekly sessions. Yet, because the child returns to the alienating parent's home immediately after the therapy session, the progress is constantly and systematically erased. The alienating parent will actively sabotage the therapy, interrogating the child afterward, twisting the therapist's words, and undoing any positive breakthroughs achieved that week. The potential outcomes of severe parental alienation are clinically catastrophic. Long-term case studies and historical trends reveal that alienated children frequently suffer from severe depression, substance abuse, and a profound inability to form healthy, trusting relationships in adulthood. They have been fundamentally taught that half of their biological identity is flawed, dangerous, and unworthy of love. Christopher is not just fighting for his legal right to parenting time. He is desperately trying to save his daughter's long-term mental health and future stability. Furthermore, this alienation frequently cross-pollinates with the false allegations we discussed previously. When simple psychological alienation fails to sever the bond permanently, the alienating parent will often escalate to directly coaching the child to make horrific, entirely fabricated allegations of physical harm against the father. This immediately triggers the involvement of state child protective services, initiating a sprawling, incredibly invasive investigation that legally suspends Christopher's access completely. Even when the allegations are investigated and proven entirely baseless, the investigation itself serves the alienating parent's primary strategic goal. It maximizes the length of time Christopher is physically separated from his child, allowing the psychological reprogramming to solidify permanently while bankrupting him in the process. You are now trapped in a vicious cycle where your own child has been turned into the primary witness against you. You are desperately pleading with the judge to recognize the blatant manipulation. But the judge is not a licensed psychologist. The judge is a lawyer wearing a robe, bound by rigid statutes and overwhelmed by a massive docket of cases. To decode the complex psychological warfare happening inside your family, the judge must outsource the investigation to third-party professionals. What happens when your entire future, your financial ruin, and your permanent access to your children are handed over to a completely unregulated industry of court-appointed experts whose very livelihood depends on ensuring your divorce takes years to resolve and costs hundreds of thousands of dollars? This refers to the sprawling, highly lucrative, and aggressively expanding ecosystem of the modern family court industry. Over the past century, as divorce transitioned from a rare societal taboo into a formalized, high-volume administrative process, the courts became structurally overwhelmed. Judges, facing dockets packed with thousands of contentious custody battles, realized they simply lacked the biological time and the specialized clinical training required to untangle complex family dynamics or verify conflicting allegations of abuse and alienation. To solve this administrative bottleneck, the legal system systematically outsourced its judicial authority to a privatized cottage industry of court-appointed professionals. Today, in the year 2026, a man walking into a family court is not merely facing a judge and an opposing counsel. He is walking into a multi-billion-dollar enterprise comprised of custody evaluators, forensic psychologists, guardians ad litem, and parenting coordinators. To understand the sheer financial devastation this industry inflicts upon men, we must examine the specific mechanics of these appointments. Let us begin with the guardian ad litem, frequently abbreviated as the GL. Historically, a century ago, the concept of a court-appointed representative for a child was reserved almost exclusively for extreme, tragic cases of severe parental death, absolute abandonment, or verifiable criminal child abuse where the state had to step in as a surrogate protector. However, historical trends over the last few decades show a massive expansion of this role. In modern family court, a GAL is routinely appointed in standard, middle-class divorces simply because the parents cannot immediately agree on a custody schedule. The GAL is essentially a private attorney appointed by the state to represent the best interests of the children. But the state does not pay their salary. You do. When the judge signs the order appointing the GAL, you are legally mandated to pay a massive upfront retainer, frequently split between the parents, but overwhelmingly burdened upon the father if he is the primary wage earner. The GAL operates with terrifying, almost unchecked authority. They are legally empowered to subpoena your medical records, interview your children's teachers, speak to your neighbors, and interrogate your extended family. They act as private investigators, gathering vast amounts of hearsay and subjective opinions, which they then compile into a singular, highly influential report presented to the judge. Because judges are so heavily burdened, they will almost universally rubber stamp the recommendations of the JL. Imagine a man named Richard, a 45-year-old architect living in Massachusetts in the year 2026. Richard is fighting a brutal parental alienation campaign and simply wants an equal 50-50 parenting schedule with his two sons. His ex-wife's attorney aggressively petitions the court to appoint a full forensic custody evaluator, citing entirely fabricated concerns about Richard's temperament. The judge agrees. This is where the true financial hemorrhage begins. A full forensic custody evaluation is not covered by health insurance. It is an out-of-pocket legal expense. Richard is immediately ordered to pay a $20,000 retainer to a private psychologist chosen from a court-approved roster. The evaluation process itself is an invasive, deeply subjective psychological dissection. The evaluator will subject Richard to a battery of standardized psychological tests, most notably the Minnesota Multiphasic Personality Inventory, or MMPI-2. It is critical to understand the historical context of these assessments. The MMPI was originally designed in the mid-20th century to diagnose severe, clinical psychiatric disorders in institutionalized populations, such as profound schizophrenia or clinical paranoia. It was never originally intended to evaluate the parenting capacity of a stressed, grieving father navigating the dissolution of his family. Yet, it is aggressively utilized in family court. If Richard scores slightly high on a scale measuring defensiveness, a completely natural human reaction when you are being investigated by a stranger who holds the power to take away your children, the evaluator can pathologize that normal stress response, labeling him uncooperative or hiding deep-seated personality defects in their final report. Following the standardized testing, the evaluator conducts clinical interviews and home visits. An evaluator might spend precisely 2 hours observing Richard interact with his sons in his home. Based on that microscopic window of observation, the evaluator will draw massive, sweeping conclusions about Richard's entire capacity for empathy, his disciplinary style, and his emotional bond with his children. The evaluator then drafts a comprehensive 60-page report. If the evaluator harbors internal, subconscious biases against fathers, or simply fundamentally misinterprets Richard's introverted personality as coldness, those subjective opinions are codified into what the court treats as absolute, scientific fact. The most terrifying aspect of this entire privatized ecosystem is the doctrine of quasi-judicial immunity. Because these evaluators and guardians ad litem are appointed by the judge to assist the court, they are heavily shielded from civil liability. If Richard discovers that the custody evaluator blatantly ignored hard evidence of his ex-wife's alienation tactics, or if the JL entirely fabricated quotes from a teacher, Richard has virtually no legal recourse. He cannot easily sue them for malpractice or negligence because the system protects its own apparatus. The court appointees operate with absolute power over the destiny of a family, with zero financial accountability for the destruction they cause, all while billing Richard at a rate of $300 to $500 an hour. This financial extraction does not miraculously cease once the final custody order is signed. Over the last 20 years, a new layer of the industry was invented specifically for the post-divorce landscape: the parenting coordinator. If Richard and his ex-wife have a high-conflict dynamic, the judge will order them to utilize a parenting coordinator to resolve minor, day-to-day disputes. If there is a disagreement over whether a child should play travel baseball or local league soccer, or if there is a dispute over a 15-minute delay in a Friday evening drop-off, Richard is legally barred from filing a motion with the judge. He must submit the dispute to the parenting coordinator. The parenting coordinator is a private referee who again bills by the hour. A simple email exchange regarding a delayed soccer practice can easily cost Richard $150 in fractional billing. This creates an environment where an alienating or highly combative ex-spouse can effectively utilize the parenting coordinator to financially bleed the father to death by 1,000 cuts, initiating endless, petty disputes that the father is legally forced to pay a private professional to resolve. The entire system is engineered to ensure that the family's accumulated wealth is systematically transferred out of their savings accounts and directly into the pockets of the court-appointed professionals, leaving the father functionally bankrupt while claiming the entire process was executed in the best interests of the children. We have completely mapped the psychological warfare and the private, unregulated industry that devours a man's resources during the legal battle. You have survived the evaluations, you have liquidated your assets to pay the retainers, and you finally have a stamped, finalized divorce decree in your hand. You assume the worst is over. You assume you can finally begin to rebuild your life, your career, and your bank accounts in peace. But you are vastly underestimating the technological reach of the modern state. What happens when the family court system plugs your finalized divorce decree into a massive, automated, federal enforcement apparatus? What happens when a single missed payment, caused by an unexpected medical emergency or a temporary job loss, triggers a ruthless algorithmic collection machine that treats you not as a struggling father, but as a severe criminal threat, utilizing vast databases to intercept your taxes, freeze your passports, and completely immobilize your ability to participate in modern society? That automated federal enforcement apparatus is officially known as the Title 4D system, and it stands as the most aggressive, inescapable domestic debt collection machine in the history of the United States. To fully comprehend the absolute peril this system poses to men in the modern era, we must trace its historical trends back to its legislative origin. In 1975, Congress amended the Social Security Act to include Title 4D, originally designing it as a governmental cost recovery mechanism. The initial logic was straightforward. If a single mother required public welfare assistance, such as food stamps or housing subsidies, the state governments wanted the legal authority to hunt down the absent father and aggressively recoup those taxpayer expenditures. However, as the decades passed, the program underwent a massive systemic mutation. It expanded from merely collecting welfare reimbursements to processing and enforcing nearly all private child support obligations across the nation. This expansion fundamentally transformed state governments into highly incentivized, corporate-style debt collectors. The federal government operates a matching fund program, directly subsidizing state child support enforcement agencies based on their collection performance metrics. The more money a state extracts from non-custodial fathers, the more federal funding that state agency receives to expand its payroll and infrastructure. This creates a deeply entrenched, systemic conflict of interest where the state acts as both the supposedly neutral arbiter of family law and the financially incentivized beneficiary of maximizing support orders. But the true unyielding terror of this system was cemented exactly a decade later, with the passage of the Bradley Amendment in 1986. The Bradley Amendment established a catastrophic legal doctrine of strict liability regarding child support arrears. It formally prohibited any state judge from retroactively modifying a child support debt. In the American legal system, almost any other form of civil debt, including massive corporate failures, credit card defaults, and medical bankruptcies, can be negotiated, restructured, or entirely discharged through a federal bankruptcy court. Child support arrears under the Bradley Amendment are entirely immune to bankruptcy. Once the debt is recorded on the ledger, it becomes a permanent, unforgivable financial anchor that will follow a man to his grave. Let us examine the exact potential outcomes of this automated machinery, using a highly realistic scenario, in the year 2026. Imagine a man named Daniel, a 40-year-old commercial freight driver living in Michigan. During his divorce, Daniel was ordered to pay $1,500 a month in child support, based on his peak trucking income. 2 years later, during a routine delivery, Daniel suffers a severe herniated disc in his lumbar spine. This is a common, documented occupational hazard, but it leaves Daniel entirely unable to sit in a truck cab. He is placed on unpaid medical leave, and his income instantly drops to zero. Daniel makes the most common catastrophic mistake men make when interacting with the family court system. He assumes the system possesses common sense and human empathy. He assumes that because his injury is medically documented, the state will automatically pause his payments. He fails to immediately hire a lawyer and file a formal legal motion for a downward modification of his support order. Because of the Bradley Amendment, the clock never stops ticking. For months pass while Daniel is undergoing physical rehabilitation. The automated system continues to charge him $1,500 every single month. He quickly accumulates $6,000 in arrears. In 2026, this debt is not monitored by a human caseworker reviewing Daniel's medical files. It is managed by a ruthless, unblinking algorithm. Once Daniel crosses a specific arrears threshold, the state computer systems trigger a terrifying, cascading sequence of enforcement protocols without a single human being analyzing the context of his physical injury. First, the algorithm deploys the Financial Institution Data Match, commonly known as FIDM. This is a sprawling federal database that interlocks all state child support agencies with every bank, credit union, and financial institution operating in the country. The algorithm autonomously locates Daniel's small emergency savings account and issues an immediate bank levy. Without any prior warning, Daniel's bank freezes his account and drains the entire balance to send to the state. He wakes up to find his liquid capital entirely erased, leaving him unable to purchase groceries or pay his rent. Simultaneously, the algorithm flags his Social Security number across federal networks. The Department of the Treasury automatically intercepts any state or federal tax refunds Daniel might have desperately needed to survive his medical leave. His name is electronically transmitted to the United States Department of State through the Federal Passport Denial Program. Because his arrears exceed the $2,500 statutory threshold, his passport is instantly flagged for revocation, legally trapping him within the borders of the legal apparatus. But the most mathematically destructive paradox of the entire enforcement machine is the automated suspension of state-issued licenses. To force compliance, the algorithm electronically notifies the Department of Motor Vehicles to instantly suspend Daniel's commercial driver's license. The state legally demands that he pay the $6,000 and then explicitly revokes the exact occupational license he requires to generate the income to pay the debt. If Daniel were a medical doctor, a master electrician, or a certified real estate broker, those professional board licenses would be suspended just the same. Furthermore, the state will suspend his recreational hunting and fishing licenses, an intentionally punitive measure designed to inflict maximum psychological degradation and isolate the man entirely. When Daniel inevitably fails to produce the thousands of dollars he owes because his accounts are frozen, his body is injured, and his commercial license is revoked, the algorithm generates a summons for a show cause hearing. Daniel is dragged back into the family court system to explain why he is in contempt of the court's order. This is the exact moment where the foundational protections of the American justice system vanish, and the modern debtor's prison opens its doors. While the United States constitutionally outlawed criminal debtors' prisons centuries ago, the family court operates a massive systemic loophole through the doctrine of civil contempt. The judge looks at Daniel's arrears and demands a purge payment, a specific lump sum of cash required to avoid immediate incarceration. The legal justification is that Daniel is not being punished for a crime. He is being coerced into complying with a civil order. Judges frequently use the phrase that the father carries the keys to his own jail cell in his pocket, implying he can simply pay the money to be released. But if the pocket is empty, the key does not exist. Because the proceeding is classified as civil rather than criminal, Daniel is frequently denied the constitutional right to a court-appointed public defender. He is forced to represent himself against a highly trained state prosecuting attorney. When Daniel cannot miraculously produce the purge payment, the judge orders the bailiff to place him in handcuffs. Daniel is transported to a county jail facility, locked in a cell block alongside violent criminal offenders, completely stripped of his freedom, his dignity, and his earning capacity, simply because a temporary physical injury disrupted his cash flow. The automated machinery does not differentiate between a malicious actor intentionally hiding vast offshore wealth and a physically broken father begging for temporary relief. It is a blind, algorithmic predator designed entirely to optimize state collection metrics, completely detached from the preservation of the family unit or the survival of the individual man. We have now journeyed through the entire devastating life cycle of the modern American divorce machine. We have analyzed the historical erasure of fault, the legal transmutation of separate property, the algorithmic extraction of wealth, the psychological weaponization of children through alienation, and the automated imprisonment of struggling fathers. The system appears absolutely impenetrable, a monolithic structure designed to guarantee the complete financial and emotional annihilation of men who sign a marriage contract. But what if this entire century of relentless systemic pressure has inadvertently forged a profound, highly organized underground counter-movement? What if, in the year 2026, a new generation of men is actively rejecting the victim narrative, meticulously reverse-engineering the family court apparatus, and utilizing entirely new legal firewalls and offshore financial frameworks to not just survive a marital dissolution, but to completely and permanently insulate their wealth before they ever walk down the aisle? That counter-movement is currently redefining the entire landscape of modern marriage in the year 2026. Men are no longer walking into the family court system, completely blind to the historical trends and potential outcomes we have spent hours dissecting. Instead of reacting to a catastrophic legal ambush, a rapidly growing demographic is actively preempting the family court apparatus entirely. They are achieving this through the strategic application of advanced legal firewalls, treating the marriage certificate not merely as a romantic milestone, but as the most significant, legally binding corporate merger they will ever sign. To understand this defensive architecture, we must begin with the evolution of the prenuptial agreement. Historically, society viewed prenuptial agreements as insulting, unromantic documents reserved exclusively for multi-billionaires and aging celebrities. However, in the modern era, the prenuptial agreement has been completely destigmatized by sheer mathematical necessity. Young professionals, entrepreneurs, and men entering second marriages recognize that a prenuptial agreement is simply a private contract designed to explicitly override the state-mandated laws of equitable distribution and community property. If you do not write your own rules for the dissolution of the marriage, the state legislature has already written them for you. And as we have seen, those default rules are structurally designed to liquidate your life. Let us examine a practical case study. Imagine a man named Marcus in the year 2026. Marcus is a 28-year-old software developer who has built a modest, early-stage technology startup. He is planning to marry. Instead of relying on the fragile defense of separate property, which we know can be destroyed through transmutation and commingling, Marcus initiates the prenuptial process 6 months before the wedding. To ensure the document is legally impenetrable, both Marcus and his fiancée retain separate, independent legal counsel. They conduct a comprehensive, transparent disclosure of all assets and debts. The contract explicitly states that the future appreciation of his startup, regardless of any active labor he contributes during the marriage, remains his sole and separate property. It waives the creation of any permanent alimony, substituting it with a predetermined, highly specific lump sum payout structure tied to the exact number of years the marriage survives. By signing this document, Marcus completely bypasses the subjective authority of a future judge. He eliminates the need for forensic accountants, business valuations, and the devastating threat of imputed income. He establishes absolute financial certainty before the vows are even spoken. However, aggressive legal strategists in 2026 know that prenuptial agreements can sometimes be challenged or invalidated if a judge deems them unconscionable or executed under extreme duress. Therefore, high-net-worth individuals are increasingly utilizing a secondary, far more robust layer of defense, known as the Domestic Asset Protection Trust, or DAPT. To comprehend the power of a DAPT, you must understand the legal concept of ownership. The family court can only divide assets that you legally own. The DAPT is an irrevocable legal structure established in highly specific, business-friendly jurisdictions like Nevada, South Dakota, or Delaware. Imagine Marcus decides to place his startup shares and his real estate portfolio into a Nevada Domestic Asset Protection Trust a year before he meets his future wife. He designates himself as a discretionary beneficiary, meaning he can still receive distributions from the trust, but he legally surrenders the direct ownership and control of the assets to an independent, third-party corporate trustee. When the marriage eventually dissolves, the opposing legal counsel will attempt to subpoena those assets. But the assets do not belong to Marcus, they belong to the trust. The family court judge in Marcus's home state generally lacks the jurisdictional authority to pierce a properly structured Nevada trust. The assets are legally severed from the marital estate. This is not about hiding money or evading taxes. It is about utilizing fully transparent, centuries-old trust law to create an absolute barrier between personal family liability and generational wealth. For men seeking the ultimate, impenetrable fortress, the educational study of offshore financial frameworks has moved from the shadows into mainstream asset protection seminars. Jurisdictions like the Cook Islands or Nevis have built their entire sovereign legal systems around asset protection. If a man establishes a Cook Islands trust before marriage, he is moving his capital completely outside the physical and legal jurisdiction of the United States family court system. If a domestic judge orders the division of those assets, the foreign trustee simply ignores the order, bound by local laws that do not recognize United States civil judgments. While these international structures require immense capital to maintain and operate under strict federal compliance reporting, the historical trend shows them serving as the absolute final safeguard against catastrophic domestic litigation. For those men who are already legally bound by a marriage contract in 2026 and missed the opportunity for a prenuptial agreement, a parallel strategy is emerging through the use of postnuptial agreements. While significantly more difficult to enforce because the marital fiduciary duty has already commenced, a postnuptial agreement acts as an emergency financial reset. It allows a couple to legally untangle their commingled assets, partition their property, and clearly defined financial boundaries mid-marriage. Often utilized when one spouse receives a large inheritance or starts a highly lucrative business, the postnuptial agreement requires rigorous legal structuring and absolute transparency to prevent a judge from later discarding it as coercive. This comprehensive, defensive awakening represents the century's final, profound change. We are witnessing the death of naive matrimony and the birth of strategic partnership. Men are sharing legal documents, studying statutory precedents, and refusing to participate in a system that historically views their labor as a public utility and their physical presence as entirely disposable. They are forcing a massive cultural conversation about the extreme risks of the current family law paradigm, directly leading to historic lows in marriage rates, as men effectively go on strike against a contract they deem inherently hostile. Over the course of this deep dive masterclass, we have unraveled the sprawling, deeply complex machinery of the United States family court system. We have mapped the historical evolution from English common law to the modern Title IV enforcement apparatus. We have analyzed the terrifying realities of the ex parte order, the subjective danger of the equitable distribution model, the mathematical destruction of the QDRO, and the psychological warfare of parental alienation. You have been armed with the raw data, the historical context, and the educational case studies necessary to truly understand the landscape. The goal of this knowledge is not to foster fear, but to completely eliminate it through absolute preparation. Ignorance is the primary currency the family court system relies upon to extract your wealth. By understanding exactly how the machine operates, you strip away its power to ambush you in the dark. You are now equipped to ask the critical questions, hire the precise legal counsel, and structure your life with the impenetrable defensive strategies required to protect your legacy, your financial independence, and your future. But while we have conquered the mechanics of the legal system, there remains a completely different battlefield that dictates exactly how you rebuild your physical and mental resilience in the aftermath of a catastrophic life event. What exact biological protocols, psychological frameworks, and high-performance habits are divorced men utilizing in 2026 to systematically reconstruct their lives, achieve peak physical condition, and dominate their professional fields after losing everything? That is a journey into complete human optimization, and it is a discussion we are going to begin very soon.